Hi, I'm Leyla from Basics Legal, and I will be talking to you today about the commercial contracts. So basically, any contract in commercial law context. I'm a legal consultant and an educator. Before we start, you can follow my channel and for more commercial law based related content. In this channel, once you've subscribed, you'll see my previous two previous videos about defamation and incorporation of legal knowledge in education systems. One of them, which was streamed live. Also, before we start, I just want to reiterate that in all of my videos, I refrain from using big words or what we call legal jargon, so everyone can understand them and not get bored while watching them. My videos are for everyone, and not just lawyers or people in legal field or law students. It's for everyone. And so I tried, as you'll see, I try to oversimplify every concept and I explain them as plainly as possible. So let's go to the next slide. What is a commercial law, a commercial contract? I say commercial law a lot, so sorry for the slip up. Well, before we define that, we should first define what a contract is. A contract is a legal form of agreement in written form that is binding on the parties. With the contract, the parties exchange obligations and assume responsibilities towards each other. Without contract, the world will be a lot less reliable place. Almost nothing will be done. No progress will be made. There'd be no trade. There'd be no interstate relations, no unions, and no economies. A commercial contract is an agreement between two or more businesses that are engaging in a transaction or any contract that's created to govern the exchanges of a commercial nature. Commercial contracts are not a thing of the past. I think not a thing of the modern world. We've seen many traces of commercial contracts from the past. Contrary to many beliefs, there have been ancient legal systems and regulatory bodies enforcing laws in ancient societies. One of the finest surviving pieces of evidence is from the Hittites. It was called the Code of Nephilim. It's dating back to 1500s BC. Inscribed on stone tablets like the one here, it served as guidance for the Hittites to keep the order in the kingdom. Most forms of contracts would be enforced based on this legal code, and disputes will be solved according to that. This particular bill of sale here is much older than that. It is a contract between the parties called Shini Ishtar, I think I'm pronouncing it right, and the seller from Sumer, an ancient civilization. Of course, the details in this agreement isn't as fancy as the contracts of today, but the details in this contract, the clarity, it's astounding. The parties are identified, as you'll see from this text here. I tried to put the translation. The parties are identified, the nature of the exchange is identified, the description of the real estate in question is so well written in this short and concise piece of agreement. This, of course, is not the only one that survived to this day. There have been many more like this, which has helped people in the past get things done, really. Findings like these also helped the modern man, let's say, to understand how formal agreements were formed in the past. A little fun fact, the oldest known contract is 4,300 years old. The oversimplified definition of these contracts in the past was that one party traded goods or services for something of equal value from another party, such as 5 silver coins for a cart or 3 coins for a bag of flour, and etc. Over time, the meaning of objects bought or sold has changed with the new norms and customs of societies or of the time. Many things once considered commodities, something that can be bought and sold, would be immoral and illegal to do so today. Like this one example right here. It is a contract for the sale of a slave dating back to 1401, I think, yeah, AD. As absurd as it may sound, back then, even a human being was considered a commodity. Owning slaves was a big part of ancient societies, and often they were priced higher than most goods. Therefore, obtaining conclusive contracts for such purchases of high-priced commodities was considered a smart move by slave merchants, people with high status, people who owned lands and houses and households that, they run with the slaves, with the help of the slaves. Once bought, these slaves would be, then they would become highly important component of the household. And therefore, a bill of sale was important because in the case the owners decided to resell them or then go for an exchange. Of course, there are other forms of contracts that were considered purely economical in the past, but now they're not so much. Marriage, for example. For instance, it is legalized with a form of contract that was accepted to be an economic exchange, which today, not so much. Because, of course, there is still economic component to that. Financial, for example, how can I give an example? It is share of household income, unification of household income and sharing of the assets, basically sharing financial obligations. So these can be counted as economic exchange or it has this component to that. But for these days, it's much more a contract for union and companionship and not so much economic in terms of economic context. And however, in some cultures, even like now, marriage is still purely an economic exchange. Let's come back to the present. There are different types of contracts that can be classified as commercial contracts. Here are some of examples I put here. Obviously, the sale of goods is one of them. The use and or transfer of intellectual property rights is also a form of commercial contract. Use of others' intellectual property without any financial gain causes no issue, as long as the original creator or the owner of the IP is credited. However, use of others' IP for profit requires commercial dealings with the owner as well. Transferring IP rights or using the IP will generate profits, which will then be paid to the owner in the form of royalties. These are regulated and facilitated by pricey contracts. These are very common and popular in the entertainment industry, as well as other creative industries. Another example, which may not seem commercial at first, is employment contracts. Offering one's services in exchange for a sum is a commercial exchange, basically. Other exchanges, such as taking a loan from a bank or leasing a property to use for commercial purposes, they're all commercial in nature. Therefore, contracts pertaining to these exchanges are commercial contracts. You get the idea. Why have a written agreement at all? Well, firstly, certainty. Because unlike verbal agreements, written agreements set no limit to the length of sentences, details of the exchange, the parties, the goods, and etc. The written piece always allows parties to eliminate any misunderstanding while executing their obligations. So we'll talk about all of these in a bit later. Secondly, enforceability. So enforcing the terms of the contract means you can force someone to do their bit, be it through a court or through, official mechanisms in place within that contract. Because they can't then, once signed, they can't then turn around and say, nope, I did not agree to that, or I did not say that, I did not mean that. And because the contracts they do not only serve as a detailed guide on what to do and how to do it, but also define what the parties actually meant when agreeing to the terms. This, as you can see, ensures that the parties are not confused by the initial wording and they get explanation by the interpretations given in the contract, which we'll talk about more in a bit. Contracts also serve as a protection. If a party refuses to fulfill their obligations, fails to execute them properly, or just anything deems the agreement annulled, there are clauses in the contract that allows parties to seek compensation or suitable remedies. Without such written protective clauses, the people will be unwilling to enter into contracts at all. And last but not least, the dispute navigation. I personally believe a well-drafted contract includes lengthy guidance on what to do in case of a dispute. Because when the parties enter into a contract, they're usually in good spirits. They trust each other. The business is going well. No one expects to be in a dispute with the other party anytime soon. However, it happens more often than not. The inclusion of clear guidance on what makes a contract effective is what makes inclusion of a good dispute guidance is what makes contract effective, basically. Because it's all good and jolly until, let's say, one party is wronged. We'll talk more about this in a bit in detail. As I said, let's talk a little bit about these in detail. When two or more parties agree to start engaging in economic exchanges, there are a few things that are specified within their contract. The most important bits of information are always on the first page. Depending on the complexity of their dealings, the nature of the exchange, the specifications include the rights and obligations of each contracting party. They're all on the first page. In a leasing contract, for example, a party A will provide the space or venue to party B in return for a certain amount of money. Within that contract, details such as the amount to be paid, payment intervals, if there are any installments, any commissions, any tax, mode of payment, how it will be paid, what kind of mode of payment is accepted, what not, and timeline of the payments. And it's just overall payment information, overall exchange information is all there. Then again, depending on the parties and the nature of the contract, details such as full name, patronymic, because in some cultures, name of a father is part of full name, national ID number or passport number if it's an international deal, if the parties are from different nationalities, full addresses and job titles are all usually present there. Other pages of the contracts usually specify or they contain information about remedies, duration of the contract, mode of communication, which is very important in contracts, and sometimes the rights of a third party, should that be the case. The reason these specifications are so important is that without them, a contract would be unworkable. Things we do not usually mention in verbal agreements or normal conversations is they're often meticulously included within a written contract. And the reason I kept saying depending on the contract is that unlike non-commercial contracts, most commercial contracts will require full details for everything. The more detail, the smoother the business. This brings us to the main role of contracts, especially in commercial context. All the businesses, investors and startups and manufacturers, you see all of them that we see all around us. They all function and conduct effective commercial exchanges due to detailed contracts. Drafting these contracts can cost up to thousands or hundreds and thousands of dollars or pounds. And almost every business owner consults a lawyer or a law firm to draft their contracts, to do their negotiations, all to protect their interests, their assets, and profits. This does not mean they do not trust the other party. On the contrary, demanding a formal agreement, formal contract, or at least expecting it from the other party is a sign of true partnership. This also means both parties wish to have a lasting partnership with mutually beneficial results. Contracts not only protect the wealth of the parties, but also certain clauses within a commercial contract protect their intangible assets. For example, their reputation, privacy, and right to truth in the event of a broken partnership. What do we mean by that? A contract is a perfect piece of evidence in case one party is accused of breaching the contract or not fulfilling their duties. Specifications we talked about earlier do protect the parties in case they are wronged or in case there's a misunderstanding. When we talk about privacy and confidentiality, the confidentiality clauses within a contract, it protects their reputation, that no information leaks out from this partnership. There is a very important clause in every commercial contract called the force majeure. I don't know if I'm pronouncing it right, but I've never. So it's basically, I think, French. This clause gained immense popularity during the COVID-19 pandemic. This clause often releases the parties from any liabilities in cases of what we call acts of God. This means the parties are not held liable for breaching the contract if something happens that is totally out of their control and was completely unforeseen. The list for force majeure clause is often not limited, but usually implied for things such as war, a coup, a natural disaster, and an unforeseen crisis, or basically any act of a third party that was unforeseen or was totally unpreventable or unavoidable. COVID-19 pandemic created, unexpectedly of course, created a stall on the world market, and hundreds and thousands of businesses either went bankrupt or took hit because they failed to carry out their part of the contracts, or vice versa. However, some of those who had well-written contracts could find remedies, even if it was partially. Many large corporations managed to obtain subsidies from either governments or equip themselves with tougher means to navigate through the crisis created by this pandemic. Another important point about the contract that it is enforceable. What do we mean by this? Verbal agreements consist of a handshake, maybe one or two witnesses for it to come into effect. In the past, such agreements were exclusive to the kings, special high-ranking officials, religious leaders, or tribal leaders, or anyone that the community is trusted collectively. These often fail to bring parties together to fulfill their duties and often created unequal conditions. Human nature is likely to obey written commands, commands coming from an official source. So written or attested or sealed contracts have always played a similar role. Historically, every legal system has recognized and still recognizes the legitimacy of written contracts. Once signed, the parties are bound by the clauses, and each party can demand that the other fulfill their part of the agreement. And because a contract binds them, they can be held accountable in the eyes of the court for not upholding their part. This brings us to the topic of disputes. Every contract, not just the ones with a commercial component to them, contains a clause or two detailing what to do in case a dispute arises. Depending on the agreement of the parties, those clauses will include options to either take matters to court or to attempt to reconcile with out-of-court proceedings, such as alternative dispute resolution. I think every well-written contract contains clauses offering the option to opt out for ADR. The option to go through mediation or arbitration before suing your partner is a great way to solve an issue. Because as we know, court proceedings can be very costly and time-consuming. And if the contract you sign manages to keep things or keep the parties out of court and allows them to sort of sort out their differences, then it's an effective contract. In certain cases, for example, if the breach is too grave for either party to wish to reconcile or agree to a settlement, then litigation may be the best decision. Even then, a contract shall be a clear guide for the parties by providing the manner of instigating court proceedings. Among the other important clauses, confidentiality is probably one that is preferably included in every contract. Most of the non-disclosure clauses are part of unilateral contracts, such as labor contracts, IP contracts detailing technical parts of an invention, business contracts containing trade secrets. However, you can see confidentiality clauses within bilateral contracts as well. Sometimes confidentiality is implied in a commercial agreement, but it is often expressly included to ensure no detail escapes to the unknown parties unnecessarily. You will always spot a confidentiality clause when you read a contract. It can be worded something like this: parties shall not, without prior written approval of the other party, disclose to others any part of this agreement to the detriment of any of the parties, including any confidential information not specified within this contract. This here, to me, is a perfectly worded confidentiality clause, since it includes all the parties involved and covers the protection of any other confidential information that is obvious in the eyes of an ordinary person. This could be things such as addresses, ID numbers, or bank details. There are other confidentiality contracts, often called non-disclosure agreements. These are not to be confused with privacy clauses in contracts. NDAs are separate contracts on their own and are popular in settings where there's a celebrity or public figure or a government official that is involved. You can hear about NDAs probably in celebrity parties, corporate dinners, government projects, and etc. Now that we know about contracts, let's briefly look at the life cycle of a contract. It may seem straightforward, but I've seen over and over again the confusion common people have when they define what a contract is, solely because they consider an agreement agreed even though the other party has not signed yet. Firstly, it's the drafting stage. One party drafts the contract and sends it over to the other party to have a look and confirm, and just have a look and read. Second stage is once read and see the content of it. If they don't like something, they can refine it. If they want to add something, they can amend it. If they can make changes, and then they do that and then send it over to the other party. Once confirmed, the third stage is signing. Once signed, the contract becomes binding. So all the parties, signed, are now they're bound by it. Next stage is once the contract reaches its expiry date, parties communicate once more and they decide whether to continue their dealing or not. And they can revisit the clauses and make new agreements, make new additions or amendments, or keep it the same way. And then they will decide once if they want to renew the contract or terminate it based on their dealings. As a lawyer, I always say this: the clients come to us when they hit a rough patch and disputes arise. When we are presented with the contract, we go back to the beginning. And often what we discover is the mistake was made. This mistake has been made during the drafting stage. Poorly drafted contracts are one of the main reasons for later misunderstandings between the parties and thus leading to disputes. Most of the time, either the parties or their representatives did not pay attention to the details during negotiations phase, or their lawyers just did not do a decent job in creating the contract. It is always important to have your contracts double-checked and allow enough time for the other party to do the same. This will save all the parties a lot of headache and hassle in the future. It is very important to talk about unfair contracts. I feel like not many lawyers or educators talk about this often. Commonly, when we think about contracts, we think of legality. The presence of a contract often automatically feels safe. However, things like contract entrapment, unfair clauses, zero liability clauses, contracts arising out of misrepresentation, contracts resulting out of duress, and many others that they're not discussed extensively in legal spheres. Typically, in a bilateral contract, all parties assume responsibilities towards each other. And if a breach occurs, they will be liable equally or accordingly. An unfair contract can include terms that allow one party to limit or avoid their responsibilities while not allowing the same for the other party. They can also limit their liabilities and make changes to the terms of a contract. They can end it, demand compensation for any breach, or allow longer time periods and for themselves, all while denying these to the other party. One that I saw recently in a contract was written this way: Party A reserves the right to terminate this contract at any time without the need to disclose the reason for termination, without the need for legal proceedings, and or without any liability whatsoever. I'm sure you can see how unfair this is to the other party, even though both parties had very similar responsibilities towards each other. There's a term in law that is referred to as good faith. The concept of good faith is often well appreciated in the courts of law, since any mistake made by the parties without malice or ill intention is often not punished as harshly, and it's met with lesser condemnation. If a party intends to cheat and cause the other party to lose, they will have unfair clauses included in the contract. This happens in a commercial relations where one party is usually less savvy and more naive compared to the other party. One of the recent cases I was approached with was that of a buyer who wanted to take back their deposit from a realtor, but was unable to do so because the deposit agreement was worded in such a way that the buyer was not made aware of an expiry date for the deposit to be claimed back. According to the laws of the country the buyer was in, if they did not agree to it explicitly in the contract, the realtor had to give back the deposit without a time frame. So it was a clear case of a realtor entering into a fully legal contract with bad faith. The buyer had to threaten the realtor, which eventually resulted in them settling their case, of course, out of court, because the realtor was aware of the treatment they would have received in the court if this bad faith was discovered. This brings us to the topic of unenforceable contracts. There are many reasons a contract can be deemed unenforceable. Firstly, a contract should be fully formed and signed to be enforceable. As I mentioned earlier, when I talked about the life cycle of a contract, if one party hasn't signed it yet or has not signed it adequately, for example, some contracts require a stamp as well if it's a company. If it's not signed adequately yet, then it is not an enforceable contract, obviously. Courts will often look at the way contracts are formed as well, not just what happened afterwards. Of course, the parties must come to an agreement in good faith, but the contract becomes unenforceable if other factors are involved as well. One of them is one party not being fully capable of understanding what they're agreeing to while signing a contract. If you know what I mean. They must be fully aware of the content, their obligations. They must be made well aware of what their obligations are and what the liabilities will be in case of non-execution or non-compliance. Other things such as one party being heavily influenced to sign a contract or them signing because they were beguiled by misrepresentation from the other party. Mind you, concealment also counts as misrepresentation because it deceives the other party by hiding details that may be material or a deciding factor in their signing their contract. Another situation where the courts would deem a contract unenforceable would be if it was against a public policy. An example would be if contract allows illegal activities or limits the statutory duties of a professional, such as doctors, shown here, solicitors, police officers, and anyone who holds a statutory duty to the public. Sometimes the contract becomes unenforceable when they're just too impossible to execute. This happens often with unreasonable time frames put forward by the parties. I've seen this especially in commercial contracts where parties are from different time zones. For example, giving 3-day grace period. This can be just 2 days for people from different time zones. This definitely can make it impossible for certain obligations to be fulfilled, so thus making the contract impossible to work with. There are different ways a wronged party is compensated in case the matter is taken to court. I would like to talk briefly about the different types of awards court are likely to give to the wrong party. The first is compensatory damages. They are common all around the world, and it is intended to put the non-breaching party in the position they would have been if the contract had been performed as agreed. If the wrong party ends up forfeiting something, be it monetary, intangible, the courts will try to compensate them for the original and put them in your original situation before they entered into the contract. If one party's business suffers great losses, financial losses, as a result of this, breach of this contract, they will be compensated the required amount to help them recover so they do not lose their business. So they will be put into the situation they were before. Unlike compensatory damages, which are often directly determined by the courts, liquidated damages are damages that are expressly provided for in the contract in the event of a breach. They're intended to provide a certain level of compensation to the non-breaching party and can be either a fixed amount or a formula for calculating the damages. An example would be a clause in a contract providing limitations to each party, such as parties are subject to, if I'm giving an example here, parties are subject to monetary damages not exceeding $50,000 in the event this contract is annulled or one party fails to execute their obligations. It may sound unfair, but certain mid or low price contracts contain such clauses to prevent unnecessary awards in the future that may be requested by any party. I personally wouldn't include such definitive amounts in the remedies section of any contract because, well, we may never know what would happen. Courts may also order the breaching party to perform what is called a specific performance. It is an order requiring the breaching party to perform their obligations under the contract. This remedy is usually only available if compensatory damages or liquidated damages they're not there or they're not adequate to compensate the non-breaching party. And if the subject matter of a contract is unique, of course, so this is also a factor. For example, in the case of a real estate purchase, if a seller decides not to sell, even after the receiving party, even after receiving the funds, the court may order the seller to complete the purchase process as per the original contract. This is a type of injunction. And injunctions are also court orders that either press the wrongdoing party to fulfill their obligations under the contract or to perform extra acts to the wrong party, so the wrong party does not end up in an unfair situation. Because all of these are a form of, I would say, compensation. So the wronged party they do not end up in a position that they lose something. Rescission is a remedy that allows the non-breaching party to cancel the contract and be returned to the original position they were in before the contract was entered into. This is typically only available if the breach goes to the heart of the agreement. The earlier examples I talked about, misrepresentation, concealment, contracts that limit statutory duties, these are all can be reasons for the parties to successfully rescind their contract. The courts will agree and most likely award it, especially if these factors make up a substantial part of the contract. Let me give you an example. This is a real-life example. You enter into a contract where you order white cupboards for your new business. You specify in the order email that you would not accept any other color except white. You also mention that you will not accept any other color, and if they do not have any in stock, they should notify you beforehand. The seller agrees and offers 10 days before delivering the cupboards. Once delivered, you unpack them and you find out that they're blue. They're not even nowhere close to white color. The seller tells you that they were damaged, the white ones that you chose damaged, and it took time for them to restock the white cupboards you wanted. The seller manages to prove successfully that the damage to the white cupboards was unpreventable and unavoidable. However, they wanted to complete the purchase and not let you down. In this case, as a purchaser, you can rescind the contract you have with them, which will lead to the contract being annulled. You get your money back, they get their cupboards back, blue cupboards back, and everyone's happy. However, rescission may not always have such happy endings, because rescission often means the end of a partnership, the end of a venture or business relationships. There are various legal systems around the world, and different societies function under different laws and customs. There are two that are globally accepted, and most countries' laws do run according to them. One is the civil law system, which is basically the constitution or written law. The other is common law, which is precedent or unwritten law. Common law is derived from British laws, and through centuries of colonization, that's what I believe in, it is spread out to the world. Currently, 1/3 of the world uses common law or hybrid systems. The majority of the world still uses the civil law system, including the US. When it comes to commercial contracts, almost every country or legal system allows a certain level of freedom so that the contracts are self-governing. The intrusion only comes when there is a court involvement due to a breach or when there's a dispute. Almost everything I talked about today is universal, although some of you listeners from common law countries would spot my legal background throughout this video as well. The remedies I talked about earlier are almost the same everywhere. The courts will attempt to compensate the non-breaching party as much as they can through the legal mechanisms available to them. However, certain statutory aspects, of course, depend on the country. For example, in some countries, concealment do not add up to misrepresentation. And in some countries, misrepresentation is not good enough of a reason for a party to end their contract. This happens often in a civil law system where the constitution is often rigid and very definitive about the capacity of a fully grown adult to make conscious decisions, including signing a contract. So it basically says if you're a grown person with a sound mind, you know what you're signing. I personally believe common law has better tools to make use of when it comes to sorting out contractual issues. Civil law can offer more general remedies, and the parties involved may not feel like the court decisions are tailored for their case. Wherever you are, whatever contract you are planning on signing, please always try to consult a lawyer, especially if you are entering into a life-changing deal, such as bank loans, expensive purchases, giving away certain rights like IP rights, or just anything that may yield irreversible changes to your life. Lawyers or consultants are always in a better position to advise and assist you. Unlike the information you will find on the internet, the ones you Google away, an expert approach will have a bespoke evaluation of the situation that you're in and tailor the information to your case. Finally, thank you so much for watching this video. I hope you learned a thing or two about the commercial contracts. This is such a huge topic, and in this short video, I tried to make it as simple as possible. As I mentioned in the beginning, I oversimplified every concept, every step of the way. And I hope you enjoyed it. And for more commercial law related content, please follow, subscribe to my channel, comment and like Basics Legal. Thank you, everyone.